And I did practice this morning, so we'll see if it actually works. Slideshow. All right. Are you guys, can someone just let me know if you can see my screen?
It works.
And then are the slides actually even flipping?
Yes, they are.
Oh my gosh, hooray. Okay, that's awesome. The simple pleasures in life, right? Okay, so I'm Emily Vigneri. Like I said, I'm an Assistant Attorney General for the Critical Area Commission. I have been with the Attorney General's office about 12 or 13 years. About 5 of those years I've been with the Critical Area Commission, and before that I was at the Maryland Department of the Environment doing wetlands work. So I am very happy to be here today. I definitely, like Charlotte said, encourage any and all questions during the presentation. If you just need a clarification or you have general questions about certain things in the presentation, please, please, please come off of mute or put something in the chat and somebody will let me know that there's a question in the chat. I definitely encourage that. And like we said, if you just have a specific question about a specific case, I would like to hold those until we're done recording. So I'm just going to dive in and get started. We are going to talk about enforcement today, and there is absolutely no presentation from a lawyer would be complete without a disclaimer, of course. So my disclaimer is that I am not giving you legal advice, and I'm not speaking on behalf of the Attorney General himself. This is the agenda. We're going to break this into 5 parts. The importance of the critical area enforcement, provisions of the law, the process, and then certain in-depth topics, and then finally assistance that the Critical Area Commission staff can give you, assistance that the Attorney General's office can give you in doing your enforcement procedures. And I will also stop at the end of each of those sections and ask if you have questions. The slide, you will definitely get the slides at the end of the presentation. So don't worry about that. We'll send them to you. And the first topic is the importance of critical area law enforcement. Some of these are obvious. Some of these have to do with the law itself. Some of these are more policy reasons. But for us, it's important to enforce critical area laws because the critical area itself is a valuable, fragile, sensitive, natural resource of Maryland. And we all know that human activity can cause immediate and adverse environmental impacts. And on top of that, there is a statutory reason to do this. There's a statutory goal of providing for habitat conservation and water quality benefits. And then finally, there's a statutory reason in the law that the commission has an oversight role, and they have to ensure that critical area programs are effectively and uniformly enforced and implemented. As you all know, local jurisdictions have the primary authority to implement critical area programs. So you guys are the first line of defense. We are there as backup. We are there to help where we can help, but you all have that first line of defense in terms of enforcement provisions and enforcement procedures in your local jurisdictions. And then some of the policy reasons are obviously public perception, making sure that the critical area laws are enforced, making sure that there's a level playing field among those enforcement procedures, and making sure that everything is equally applied to everyone. All of those laws are equally applied to everyone. And then finally, to prevent recurring problems, right? You don't want one person to get away with putting something in the buffer and then have the neighbor do the same thing and the neighbor down the road do the same thing because they saw that the first person did it, right? So we want to make sure that we kind of nip in the bud any reoccurring problems. And I'm sure you guys can think of other reasons that it's important to enforce critical area laws, but these are just some of the ones that we came up with and that are important to keep in mind, and that I will repeat a few of also as we get through the presentation. So first things first, we have to talk about the law itself. There will be handouts also that we will give you after the presentation is over. So those handouts will include the provisions of the law. So no need to write any of these down at this point, but I just wanted to let you know we'll get those out to you as well. So the first thing we're going to talk about is the big picture. What are the minimum elements that have to be in every critical area program? The law is very clear that local critical area programs must include enforcement provisions. There's a lot here where you're going to hear me say shalls and musts, and this is one of the musts, that there have to be enforcement provisions in every critical area program. Specifically, there are 4 topics that the law calls out that have to be part of every enforcement program. There are penalty provisions. There are considerations of penalty factors. I call them the penalty factors, administrative enforcement procedures, and then the after-the-fact variance process. We will get into each of those topics more in depth towards the end of this, but I just wanted to lay them out here so you have them all in one place. So this is what the minimum elements are of every critical area enforcement program. You might ask, well, our jurisdiction is different than that. We don't have the exact same provisions that are in the critical area law. And that's okay. That can be okay. They can be different than what's in the critical area law and regulations. But the important piece here is that those provisions in a local program must be at least as effective as the enforcement requirements under the critical area statute. So those are the important words, at least as effective as what's in the critical area law, and that must be approved by the critical area commission. Like with any text amendment or program change, you can't make that change in your critical area program without the critical area commission approving it and making it officially part of your program. And then you might ask, what if a local program lacks specific enforcement provisions? There's a lot of words on this slide, but basically what this boils down to is that the critical area law and regulations are the default. They are the backstop. They apply regardless of what is or is not in your program. So even if, for example, the critical area statute changes, or if certain regulations are enacted, those apply as enforcement provisions regardless of what's in your program. So that's all in natural, and I forgot to say this in the beginning, I'm sorry. NR on the slides just refers to the natural resources article. And those are the provisions that we'll give you afterwards. So, so that was all in Natural Resources Article 8-1808. Now we're going to move on to the requirements in 8-1815. These are the shalls. These are the things that local jurisdictions are required to do based on critical area law. You are required to take an enforcement action when you identify a critical area violation. You don't have the choice to identify a violation and not do something about it. You have to do something about it. And again, we'll talk about what those things are later on, but you have to take some action. A local jurisdiction also has to require restoration and mitigation. You can't do one without the other. You have to require the property owner or the violator to bring the site into compliance and address appropriate mitigation measures. And then finally, a local jurisdiction is required to collect a bond or other financial surety measure when the restoration mitigation involves more than 1,000 square feet or more than $1,000 of expenses. Those are kind of the big ticket items in 1815 about what you're required to do. And now this gives you some options for procedures when you do identify a critical area violation. What kinds of things can you do? This is just in the law. There are other options that aren't in the law that you also have, but this is the basics in the law. You can bring an action in circuit court or district court. You could also bring a criminal case, which would be a misdemeanor, and the details are on there about what the fine would entail and even prison time in certain cases.
Hey, Emily.
Yep.
I'm sorry to interrupt.
No, please do.
Mark Carper has his hand raised, so I just wanted to give him, I'm guessing he has a question. So
Yeah, please do. Thank you, Charlotte.
Yes, I do have a brief question regarding the bonds that you mentioned.
Yep.
Must they be bonds, or could there
No.
be some other form of sureties?
Yes, they can be some other form of sureties. Yes,
Okay,
they do not have to be a bond. Yep, good question. Mm-hmm. Anything else, Charlotte?
Nope, I think that was the only question I saw.
Okay, thank you. Okay, so these, like I said, are the options that you have. You can bring an action in circuit court or district court. You can bring a criminal case. You can request assistance from the commission in an enforcement action. You could also request that the chairman refer an enforcement action to the attorney general. Those are the things that are laid out in the law. This is in addition to whatever your regular I call compliance assistance is, or in addition to whatever your regular notice of violation process is. These are, again, just the authority that this critical area statute gives each local jurisdiction. You can also, I'll mention this again later as well, you can also try to refer cases to the environmental crimes unit within the Attorney General's office if you think something rises to the level of a crime. The critical area statute also gives you authority to access a property when you identify a violation of critical area law. It tells you that you have to make a reasonable effort to contact the property owner ahead of time. And then if access is denied, you are allowed to contact your attorney and seek an injunction to actually get access to the property to pursue that enforcement action. And then the third section that we're going to talk about, so that was 1808, 1815, and now the third section we're going to talk about is 1815.1. And in this section, it is specific to tree cutting and tree clearing in the critical area. There are special provisions that were added to the law just to deal with tree cutting and tree clearing. They require, well, what you can require the violator to do is actually replant the trees where the cutting occurred, and then under a plan that's been approved by the state forester or a registered forester or a registered landscape architect. So those are the requirements that you are allowed to ask for if there's tree cutting and tree clearing in the critical area. You can also ask them to stop the violation, and then you can also ask for damages in any of your enforcement actions. Those damages have to be assessed by the circuit court, but they can be equal to the cost of replanting the trees, and they must be paid by the violator.
Emily, Aaron has his hand raised.
Okay, cool.
Must the plan be developed by a state forester, a registered professional forester, or a registered landscape architect, or does the jurisdiction have discretion if they feel like the plan fulfills the requirements, but the person who wrote it does not, or who wrote the planning plan doesn't have one of those professional certifications?
That's a good question. The law says that it may, right? That you may require the violator to have one of these plans prepared by a registered forester or registered landscape architect. So I guess you do, I would say that you do have that discretion. I think I would probably encourage you to follow the route of the registered forester or the registered landscape architect, but if you have that expertise on your staff, then there's no reason not to use it, in my opinion. I don't know if critical area staff or Kate, if you would have a different answer to that.
This is Kate. I don't think I would have a different answer, Emily. I think maybe I would encourage, though, local jurisdictions to reach out to the local DNR forester. And maybe they can review a plan as well and provide you some guidance. And I think our staff would be happy to provide assistance to connecting to the foresters. So I would just add in that they're a good resource and may be helpful.
I guess in Cecil County, we have when we do identify a violation, a lot of times the local professional engineers are drawing up the mitigation plan. So it was just a question. That's the circumstance that I'm looking at. So.
Got it. Yeah, so this would be, right, we can, and we'll talk about mitigation in more detail too. But again, this is just the law lays out the authority that you are allowed to ask for. So this is why this is a may. This is saying that this is a requirement if you feel you need it to get the registered forester to prepare the plan. Any other questions about this slide before we move on? Or actually any of the questions, do you have any questions about any of the law, like the basics in the law itself? Nope. Okay. So now we are going to move on to the enforcement process. And I probably should have named this slide differently because there, as you will hear me say several times here, there is not one enforcement process. I wish there was, right? I wish it was that easy, but it is not. So starting out, what are the kinds of violations that we see or that we hear about that are critical area violations? You probably all know these better than I do, but certainly structures that are built without permits, development activities without approvals, forest clearing, exceeding lot coverage, exceeding forest clearing limits, filling wetlands, unauthorized RCA uses, grading, tree removal in the buffer, tree cutting, tree clearing that we just talked about. There's also, we've seen a number of cases where non-water dependent projects are installed without the local jurisdiction opting into those provisions. So an example of this would be, a restaurant out over the water where the local jurisdiction hasn't actually adopted those non-water dependent regulations. And then finally, erosion and sediment control is not performed. So all of those, any and all of those can be violations that we've seen or that you've probably seen yourselves in the critical area. Who is the violator? Sometimes this is a really tricky question. The statute says that each person who violates the provisions of the law or violates the provisions of the local critical area program is the violator. And this can include contractors, this can include property owners, and it can include all of the property owners on a deed, not just one. Whoever is named on the deed can be cited for a violation. And this can also include any other person who has committed, assisted, or participated in the violation. Just because a property changes hands does not mean that the violation somehow goes away. I know it's incredibly difficult to bring enforcement actions against property owners where that violation happened on a previous, the previous property owner did it. Incredibly difficult to bring those kinds of cases, but the violation does stay with the property. Just because it changes hands doesn't mean that all of a sudden that violation somehow becomes legal. So that means in some cases, the current owner, let's say the current owner, there's a pool on the property, and that property, the pool is illegal. That and the property changes hands. The next property owner is not going to be allowed to increase the nonconformity, right? The next property owner is not going to be able to say, this pool is okay, but I want a bigger pool. That property owner, the next property owner has to bring that unauthorized pool into compliance, for example. That might not be the best example, but that's the only one I could think of right now. So those are the people that can be cited for a violation. And then this is just a generic enforcement process. And some of the comments I wanted to make on this have to do with, first of all, when you do a site visit. Most of you, I'm sure, know this already, but feel free to call MDE. Feel free to call the Army Corps of Engineers when you're going out for a site visit. You can get others involved because there are likely multiple jurisdictions involved in, for example, a wetlands violation, right? It might be a critical area violation. It might also be an MDE violation. So definitely feel free to reach out to other agencies. take photographs, write up your observations, document as much as you possibly can when you're determining whether something is or is not a critical area violation. Some of the other keys that make it a stronger case and make it a, for example, when you get to write the notice of violation, what makes it stronger is the work that you do in the beginning. So take the measurements if you're out there on the site, check the permit history, check the subdivision history if that's applicable. Make sure you identify the exact critical area designation. Some things are going to be violations, or, you know, for example, lot coverage clearing limits may be violated in the RCA, but not necessarily in the IDA. So make sure you know what you're dealing with when you're out there. And then a lot of times these days, these are going to involve looking at aerial photographs, going through GIS processes, especially if a violation didn't occur, you know, over the weekend. Let's say the violation occurred over several months. You're going to need to check the aerial photographs and then use your GIS to try to determine exactly what the extent of the clearing was and what it's going to take to bring the site back into compliance, whether it's a grading violation or a clearing violation or something like that. I just wanted to include some of those tips that we've seen that make it a better, stronger case moving forward, is putting the work in at the beginning. And then specific processes, this is where you all come into play more than I do. I have found that maybe not every single jurisdiction is different, but jurisdictions handle their enforcement processes very differently from one another. And as best as I can tell, a lot of those differences actually go back to where a jurisdiction gets its enforcement authority from, right? So whether it's a charter county or a code county or a commission county, depends on where they get their enforcement authority in the first place. And since the critical area enforcement provisions have to fit into those existing procedures, that's what really determines, I think, how jurisdictions handle their specific processes. All I wanted to point out, though, is that we've realized there are differences. And as I said from the beginning, the differences can be okay as long as they're at least as effective as what's in the critical area statute and regulations. Some jurisdictions use municipal infractions. Some jurisdictions go straight to district court. Some jurisdictions use notice of violations, which are appealed to the Board of Appeals before they would go to district court or circuit court, or, you know, take some further action. So really, you guys are the experts on your enforcement process and those procedures and how to fit critical area into it. But like I mentioned from the beginning, there are minimums that have to be in the law and in your enforcement processes when you're doing critical area enforcement. And finally, like I said from earlier as well, compliance assistance is always encouraged and allowed, and whatever it takes to bring the site back into compliance, that's what we would like to see, in addition to the mitigation piece of this. Any questions before I keep moving on to some of the in-depth topics, what I'm calling in-depth topics? Nope. Okay. So first thing we're going to talk about is best practices for notices of violation. Again, this is just based on ones that we've seen and ones that have worked in specific jurisdictions. We'll give you an example after the presentation of one that was effective in Somerset County. And this is kind of the list of things that make it effective and make it hold up if it's going to be appealed. Number one, I cannot stress this enough, is the specific reference to the actual local code or ordinance that is being violated. And then, like I mentioned earlier, you can cite multiple people, be clear about the critical area designation, be clear about the extent of the violation, right? Like, what are we talking about? An acre of clearing, or are we talking about are we talking about a structure that's 1,400 square feet? What are the dimensions? What are the exact measurements? Some jurisdictions do ask for surveys, and again, that would be paid for by the violator, but jurisdictions do ask for surveys in certain circumstances to verify the extent of what the violation is. I would also include details about whether it's a fresh, like a new violation, whether you see fresh tracks, what are your observations there, or whether it's something that you know, or you've done your GIS or aerial photograph research and you know that it's been over months or over years. The more detail you have, the better. The more documentation you have, the better. If the person needs to stabilize the site, consider doing a stop work order. Consider and tell them what that stabilization would entail and how long they have to do it within. And then importantly, include a deadline on everything. How long do you expect them to have to be able to bring the site into compliance, and what specifically do they need to do to bring the site into compliance? Mitigation calculations are important, as well as appeal rights. For example, a lot of notices of violation, the appeal right is to the Board of Appeals. You should let them know that. And then finally, we like to recommend that you send it certified mail, just so you have the assurance that it's actually getting to the person that it's supposed to get to. Statute of limitations. So this means how long do you have to bring a case? The law says, our critical area law says that you have 3 years to bring a criminal prosecution, and you have 3 years to ask for a civil penalty. The statute of, and that begins when you knew or should have known about the violation. There's no specific statute of limitations on injunctive relief. So this means that injunctive relief just means you're asking a violator to take some action. There's no specific statute of limitations on that, because the violation, let's say it's a disturbance to the buffer, that disturbance exists for as long as it takes to be restored. So that's why there's no specific statute of limitations on that. It continues to be a violation until it's restored. The next topic I want to talk about is after the fact variances. There are a few slides on this. And the reason this is important is because in 2008, the critical area law was strengthened to avoid what I like to refer to as the merry-go-round effect. The merry-go-round was when somebody violated the critical area law and then asked for forgiveness and requested a variance or a permit to legalize that violation immediately. So then you would just go around and around in a circle, because somebody would violate, ask for forgiveness, et cetera, et cetera. The 2008 law made clear that that had to end. And the way it did this was ensuring that the local jurisdiction had to issue a notice of violation and had to assess a penalty for critical area violations before they're even allowed to accept an application for an after the fact variance. We've seen a lot of cases about that, or a lot of matters where the process might not have been done correctly, and it just gets messy. It gets complicated when the process isn't done correctly. So that's why I'm laying out here, you are not allowed to even accept an application for a permit or a variance to legalize a violation until you've done step 1 and step 2. You've issued the notice of violation and you've assessed the penalty. Important to tell the property owner that, or the violator, that the application for the after the fact variance waives their right to appeal the violation. So the violator has to choose a path, right? They're either going to go down the after the fact variance route, or they're going to appeal their violation. They cannot do both at the same time. That's the other piece that was strengthened in the 2008 law. you have to pick. The violator has to pick which direction they want to go in. So let's pretend that the local jurisdiction has issued the notice of violation and you have assessed a penalty. What is the next step for after the fact variances? The next step is that the local jurisdiction may not issue a permit or special exception to legalize that violation until these 3 steps have taken place. And these 3 steps are to fully pay the penalty, prepare the restoration or mitigation plan, and perform the abatement measures. Again, what this really means here is that the violation has to be dealt with before they can legalize, before they can choose to legalize it through an after the fact variance. You can't kind of go through the process and figure out whether you're going to get the variance or not, and have that determine whether or not you're going to prepare a restoration or mitigation plan. No, you have to do all of that upfront before the local jurisdiction can issue a permit, issue an approval, or issue a special exception to legalize the violation. We've run into a couple of scenarios where for after the fact variances, boards of appeals hear those, right? So then you run into these provisions that tell you what the step-by-step process is. And the advice that we've given to local jurisdictions is that a board of appeals can hear a case, but they cannot make a decision until these 3 steps are taken, right? So that means, I know it takes a lot of effort and a lot of resources to get cases to the Board of Appeals. So the Board of Appeals can hear it if they want to, but they would not be allowed to issue the variance until all these 3 steps are taken. And then finally on this slide, just a reminder that if the variance is approved, and if the after the fact variance is approved, then 7-to-1 mitigation is required, 4-to-1 for the violation plus 3-to-1 for the variance itself. And then the last slide on after the fact variances, what if the variance is denied? Then the local jurisdiction has to order removal or relocation of any structure and order restoration of the affected resources. Again, bring the site back into compliance. What did it look like before the violation took place? Mitigation is required still, 4-to-1 mitigation for the violation. And then you also need to give them a time frame about when and how to bring that site back into compliance to restore the affected resources. Okay, new topic, penalties. This list is what is in the law. Again, I've cited the law at the bottom. Each violation is a separate offense. So what that means is that the clearing of the buffer is different than putting a shed in the buffer. Cutting down the trees is different than an unauthorized RCA use or something like that. So there are different, each one can be treated separately and distinctly. You can't bunch them together into one and call the whole thing one critical area violation. The other piece that the law says is that each calendar day that a violation continues is a separate offense. So again, you're counting, from the time that you first knew or should have known about that violation, each day is a separate violation. So if you were after penalties, that's how you would calculate your penalties, is based on each calendar day. Local jurisdiction shall impose a penalty, and that penalty cannot exceed $10,000. I do not know of, well, I'll leave it at that. Those are the requirements, the minimum requirements in the law as far as penalties are concerned. I mentioned that there are penalty factors, and this is the list of penalty factors. How do you actually determine how much of a penalty to assess? These are the 4 factors that you can use to make that determination. What is the gravity of the violation? How big is it? What's the extent of it? How significant is it? Was the violator willful or negligent? Did they, proceed in the face of a stop work order, Or did they start immediately to bring the site into compliance? What's the environmental impacts of the violation? And then finally, the cost of the restoration and mitigation. Those are all of the things that you can consider when you're assessing a penalty. I know some jurisdictions have a set number, right? Some jurisdictions say it's $500 for every critical area violation. Some jurisdictions say the cap is $1,000 a day, and we can bring that down depending on these factors. Some jurisdictions calculate square footage of a structure or square footage of clearing. Again, there's any number of ways to do this. The number of trees, the amount of canopy cleared, there are any number of ways to calculate this penalty. But these are the things that you should keep in your mind when you're assessing the penalty. Now, restoration and mitigation. Let's pretend that you have cited the violation, you've assessed a penalty, and now you have to require restoration and mitigation, right? This was one of the minimum requirements of the program and the enforcement provisions. Restoration is different than mitigation. Restoration means bringing the site back into its pre-violation condition. And here's the list of things that you shall do. You shall require appropriate restoration. You shall ensure that restoration is properly completed. And then the same language about the 1,000 square feet or $1,000 of expenses requires a bond or other financial surety. And then there is an option in the law to adopt some other quote unquote appropriate procedure. But again, that must be approved by the commission, and it must be at least as effective as a bond or other financial security. And then mitigation is I just wanted to mention a couple of issues that we hear about restoration. Some people say it's not feasible to bring it back into its pre-violation condition. Some people say it's too expensive to do that. Some people say that restoration will cause more problems than leaving it as is. The last one doesn't hold water as far as I'm concerned, that any kind of restoration impacts are going to be temporary, and you're trying to require that the site go back to its pre-violation condition. And even if let's say they want to challenge the mitigation, they still have to at least stabilize the site and make sure that the site is stabilized while they're appealing the violation, or going through their district court process, or however it is that they're handling the rest of their case. If they're challenging it, they have to take the minimum requirement that the restoration is properly done, and you have to ensure that it's properly done. And mitigation is very similar to the restoration components. The mitigation is to offset water quality and habitat impacts. Again, that goes back to the goals of the critical area law in the first place, is to provide water quality and habitat benefits. So the mitigation is to offset those impacts from a violation. And what's in the law is that a violator should have 90 days to complete the mitigation, unless there's an adverse planting condition, right? Like you're up against whatever the planting season is for that particular tree or that particular plant. There is some flexibility, but 90 days is the default, and that's what we should aim for in terms of mitigation. And then the last part of this slide is all the same as what it is on the restoration slide, that you have to require mitigation, that mitigation has to be properly completed, and then the same components about bonding or financial security, other financial security. Any questions about any of these in-depth, what I'm calling the in-depth topics, before we move to the last part of this presentation? Nope. Okay. So the last part of this presentation is, what can we try to help you with? What are we here to provide, and how can we help the best that we can. I have to start out by saying, unfortunately, the critical area staff does not have inspectors or enforcement staff. Kind of wish they did, but they don't. So, but despite that, they can still provide a number of helpful resources to you, answering questions about the substance of a violation, talking through the process of something, what are the options that a local jurisdiction has for enforcement, what might be the next step after you've done X, Y, or Z. Critical area staff can also help with assessing FIDS habitat. Critical area staff has served as expert witnesses before a Board of Appeals when a notice of violation was appealed. Critical area staff often includes comment letters to boards of appeal when a notice of violation is appealed. They provide any, tremendous amount of other technical assistance, whether you have questions about, lot coverage, or questions about, questions about the buffer, questions about steep slopes, anything like that. You can ask them for technical assistance. They've also just provided help with referring a case to the Critical Area Commission, exactly how to go about doing that, what words are important to use in those referrals. Critical area staff can help with what you might need in a referral to the Environmental Crimes Unit, just the kinds of things that ECU looks for, we can help there. And then if there's a violation that involves a state project, critical area staff has often been the helping to coordinate between the state agency and the local jurisdiction staff, again, just to make sure that that state project violation is timely restored. And then finally, the critical area staff does monitor significant violations. And I know many of you on the phone, or many of you on this Google Meet already know that, because we ask for updates. And the reason we ask for updates is to make sure that we know that that violation is continuing to be on your radar, and that that violation is still being addressed and trying to bring that site into compliance. What is the authority of the critical area chairman? He really has two main things that the chairman can do. The first one is that the chairman cannot, I'll start with what the chairman cannot do. The chairman cannot just come in, swoop down, and take one of your enforcement cases. Not allowed to do that. The law specifically lays out a process where the chairman can identify a failing in a local jurisdiction's enforcement. And what we do is send a 30-day letter. We say, what's going on with this? Can you tell us some more details? You have 30 days to take some action to remedy the violation. If absolutely nothing happens in those 30 days, then the chairman could refer the matter to the Attorney General. If something happens, it's more likely that we're just going to continue to track and monitor the progress on that critical area violation. Again, we do not just come down, swoop in, take a case, because you all are the primary enforcement and the primary way that violations are complied with and restored. So that's the first thing the chairman can do. The second thing the chairman can do is, in specific circumstances where there is a violation of approved plan and there's an immediate threat to water quality or fish, wildlife, or plant habitat, that's the second place where the chairman can refer an action to the Attorney General to immediately stop those the degradation of water quality and habitat. And then finally, two more slides, we get to me and my job and what I do. I am also very, very happy to be a resource to any and all of you. I'm happy to talk to staff, happy to talk to county attorneys, whatever it is that you need. I can talk through substantive issues, process issues, help you with a legal analysis of the critical area statute and regulations just to make sure you kind of know what the options are, what you are and are not required to do. And then again, happy to provide suggestions for referrals to the Environmental Crimes Unit or to the Critical Area Commission. And then finally, this is just so you're aware, I'm not going to go through these in great detail, but the Attorney General does have, the law gives the Attorney General basically 4 things that it can do. It can intervene in any proceeding. It can step into the shoes of the local jurisdiction. So if I were to be referred a case, I could do everything that you could do as the local jurisdiction and as the primary enforcement responsibility. The Attorney General has, these last 2 are rarely used, but they do exist. The Attorney General can require compliance or to restrain non-compliance. And then finally, upon request of the chairman. So the chairman has to ask the Attorney General to bring an action to address what I mentioned before, a violation of approved plans and where there's an immediate threat to water quality and habitat. That's the final piece of authority that the Attorney General's office has. So with that, I have the obligatory question slide. So does anybody have any questions about anything? Big, small, anything at all? Nope, I don't. Oh, okay.
Oops.
Looks like Neil raised his hand.
Hi, everyone. This is Neil Murphy, Deputy County Attorney in St. Mary's. Can you all hear me?
Yes.
Good.
Yep, we can hear you.
So whenever there's a critical area variance in St. Mary's County, St. Mary's County Land Use and Growth Management staff will prepare a standards letter that contains all the standards by which an applicant needs to meet in order to be granted a variance. And then they will provide Land Use and Growth Management's interpretation of whether they meet those standards, as well as sort of a historical background of the facts of each application. Do they need to do that, or are they doing more than is required?
I guess I need to understand what would the next, so after the standards letter, is that standards letter asking the violator to actually do the restoration mitigation, or
No, sure. So it's just a part of the record before the Board of Appeals. And it's also sent to the Critical Area Commission. They've been historically doing that.
Got it.
And they're just wondering whether they've had to do that, or whether they can stop and work on other things that I'm sure they are quite busy. So if they don't need to do it, they'd perhaps prefer not to do it.
Right. Does it, one more question. Does it help with the Board of Appeals case? Is it something that is important for the Board of Appeals to consider during the case?
Whether the Board of Appeals considers it, I'm not sure. It's part of the record. That I know, it is part of the record. But whether they've needed to do it as part of the state law, or whether they, so I saw Aaron pointed out that often it's part of a local zoning ordinance that's to be provided, but they're just inquiring as to whether there's any requirement from the state to be doing that. From
the state. It doesn't sound like it. I mean, I went through, I don't know of
we couldn't see one either, but we were just,
Yeah, I don't know of a specific requirement to do a standards letter or a standards report, but certainly if it's required by local, local code or local ordinance, that would be something different. I don't know. Maybe I can ask Kate or Charlotte to jump in, because I haven't seen one of these standards letters, so I'm not totally sure.
Sure. I can also, after the call, send it to Critical Area as well as you, Emily, and you guys can take a look. If my description of it was unsatisfactory in explaining it.
Okay.
Yeah, I think that would be helpful, no, because I'm not positive I know exactly what you're talking about. So
Sure, yeah, I'll
seeing
send that to you guys offline.
Okay,
it- awesome.
Thank you.
that would be great.
Of course. My pleasure.
Thank you.
Anytime.
Are there any other kind of general questions or clarifications that we need, that you might need on the presentation?
Emily, there was a question from Aaron in the chat wondering how other jurisdictions collect the penalty.
Yeah. That is a really good question. And I'm wondering, is that something maybe we talk about after we
Yeah.
Break.
stop recording and take a quick break? Yeah. Okay, so why don't we do that? Why don't we stop recording and take